Hi, everybody. This is John Wu. I'm so happy to welcome you all to Dominion Mock Trials kickoff event for our upcoming Champions Cup. I see and recognize many of the people who are currently on this call as participants, some of whom I don't recognize, but I hope to get a chance to meet you soon. For those of you who don't know me, I'm the executive director of Dominion Mock Trial, and this at the end of this month, we're really excited to be hosting our first Champions Cup, high school level mock trial competition, uh, from bringing together students from all across Canada in a celebration of legal advocacy. Tonight, we got a really exciting event planned for you with some fantastic speakers. And we have the honor of having one of our directors, Mr. JP Rodriguez, who will be using his expert skills in moderating tonight's panel. So without any further ado, would like to welcome JP to the stand.
Perfect. So thank you, John, for the introduction there, and thanks for all of you for joining us today. It's going to be great here today because we have three different perspectives here on advocacy. We have from the Crown side, we have from the defense side, and then we have from the judge's position there. So you're going to get all sorts of great tips there in getting ready for the Champions Cup, and hopefully you can take all of this and facilitate it into your preparation as well, and get ready for the competition coming up. So first, let me introduce the panel. I'll just go in order from what I see here on my screen. Deputy Judge Robert Basinder, who's going to tell me just call him Robert soon enough, but he has a wealth of experience, 30 years. Sorry, I thought that was me there for a second, but 30 years of practice experience in personal injury litigation, both on the claimant side as well as insurers. And he also has mediation and arbitration services through Basinder Dispute Resolution. And he does online educational webinars and things like that through his Basinder Learning. And of course, he is a deputy judge in the small claims court. So thank you so much for joining us here, Deputy Judge Robert Basinder.
Thanks for having me.
All right, next up, we'll go to the side here of the Crown, and we have Isolt here joining us. She went to U of T, where she majored in biology and psychology, and applied to law school on a whim after an experience in a basement lab where they wanted her to execute fish. So I think in terms of origin stories, that's one of the best ones there. So she went to Osgoode, graduated in 2018, articled at the Crown Law Office in the criminal division, and since then has been working as a Crown. She prosecutes a lot of cases involving violence against children and runs back to back trials without end. So you're going to get a lot of experience for someone with a lot of trial experience, as well as certainly now with trials being done remotely. So thank you so much, Isolt, for joining us as well.
Thank you. Happy to be here.
And last, but certainly not least, from the defense perspective, we have David Robinson. No relation probably to the San Antonio Spurs player there, but David entered law school with a desire. He wanted to get into criminal law, and I think a lot of people come in and then they end up, I think today was the OCI days, into corporate law, but he stuck through it there. He did the great criminal law intensive program, and where he learned that hands-on skills, and his passion for criminal law continued to grow. He believes that people are underserved by the legal system and seeks to provide access to justice, compassion, and legal excellence as he vigorously defends his clients. And he is now a partner at, I always miss one of the names there, but hopefully I get it, Rosonic, O'Connor, Robbins, Ross, and Angelina, or Rorga there. So thank you so much, David. I hope I got all the partners in the name there. Thanks for joining us as well.
Happy to be here. Thank you very much.
All right, so let's start very from the start. Now all of these students are getting ready in preparation for a mock trial. So in terms of, maybe we'll start with you, Isolt. When you get wind that I'm going to have this trial, and I've got carriage of the file and it's going to trial, we were not able to resolve the matter, what is the first thing you do when preparing for a trial, when you're looking over everything there? What do you do?
The honest answer is I called defense counsel again just to make sure we can't resolve it. But after that, the very first thing is to read it just cover to cover, which is never a step you should skip. It sounds small, but it's really, really critical because there's usually little details and things that people haven't seen, especially in my office. It's so insanely busy. I work in appeal and that often no one's ever really done it since maybe the bail hearing. So I just try to learn it inside and out. And then I go through and I take a sort of critical assessment. It's like, what is the bare minimum amount of evidence I need to really produce here? Because we're very strapped for time in COVID. And typically at that point, you start looking at what you're trying to prove. And that's where you want to really pull out your criminal code and say, you know, what are these offenses and what actually makes them up and what evidence kind of fills in each of those pieces that I have to prove. And you work backwards from there to make sure you have everything you need for the trial. And then I usually meet with people and explain to them how the crazy justice system works once I've selected those unfortunate individuals that have to be my witnesses.
Great. Now, David, on the other side, is it any different? So you've really pushed hard through the Crown pretrial, judicial pretrial, and you're not getting anything. You're saying like, hey, wait, the systems are backlogged. We need to resolve this, and they're saying no, we're not offering anything. Your client, we're offering jail time, got to take it or leave it. And you're like, no, what? We're going to go and take this to trial. What do you do when you make that decision? Now, how do you prepare for trial?
Right. So actually, just taking a step back before preparing for trial, I guess this counts as preparing for trial, but it's before that Crown pretrial and judicial pretrial phase. Depending on the case, but in almost every case, I always want to get my client's version of events or at least some version of their events up front, because the criminal justice process is super, super long. And so people's memory starts to fade after a while and they forget important details. So I just want something really simple, like a Crown synopsis, so I have some idea of what I'm dealing with. And then I want to get I don't necessarily want their entire version of events, because I don't want to find out. I don't want them confessing to me or anything like that. But I do want to find out, is there an alibi? Are there any witnesses? Is this witness credible or not? And, were there any breaches of your rights or anything like that? Those kinds of things. I want to ask them questions. So I do a basic interview with my client first, just to find out either their version of events or the pieces of information I need when I'm reviewing the disclosure. So then I'll do what Iseult said, read the disclosure cover to cover. I'll often skip the police notes because they're almost impossible to untangle and take me the longest. So I'll read like everything else and then I'll come back and do the police notes. And then after that, I'll usually have a second interview with my client and I'll give them a sense of the strength of the Crown's case, in my opinion. But then I'll also clarify things that may be outstanding from the first interview that I had with them. And then preparing for trial, what I will normally do is you get a list of witnesses that the Crown is going to call. And then what you want to do is essentially write out what you want to get from each witness. So you might have like a series of points that you need to get out of witness A, and then a different series of things you need to get from witness B. So you have kind of a skeleton of what your cross-examination is going to be for each Crown witness. And then you can pour over the disclosure some more and make sure that you write out all of your questions for that person. And then one thing that maybe is a little bit different at our firm is we're a firm that regularly calls our clients to the stand. And so we spend a lot of time preparing our clients to testify. So we'll do a lot of mock direct examination with our clients, and then we'll call our other partners in and they'll do cross-examination of our clients. So we do a lot of that sort of thing to prep our clients for taking the stand.
Okay, and then Robert,
Yes.
when you look at a trial that's coming on before you and you're going to be adjudicating it, what are the things like when you're looking at in small claims court? How much time do you spend on terms of looking over the pleadings? What are you kind of doing in terms of getting ready to hear the arguments and the evidence that's going to come forward?
Well, I guess the best way of answering is by saying I don't know, because up until March of 2020, I was doing this all in a courtroom, and we haven't had any trials in at least in the small claims court, up until very recently, and they're all being done remotely. So preparation and timing is very different. So I guess in the old days, what would happen is I wouldn't know about a specific trial really until a couple of days potentially before the trial. As a judge, you get your list and you don't get the files that far in advance. So if a trial is on Friday, potentially the list isn't finalized for me until Tuesday or Wednesday of that week. And it's only if I go into the court ahead of time that I can actually look at the materials. Now, with COVID and the pandemic, everything is being done online. Materials are being made available to judges a lot earlier. And it's probably true with all electronic hearings. So potentially, if I have a trial next week, by now I've already got access online and I can read through all the materials that have been filed. But that's usually not the first preparation I do. The first preparation I do is I bring out my best friend, the Book of Rules, and I look at it and I refresh my memory. What do people have to do? What does, in a civil case, what does a plaintiff have to do? What does the defendant have to do according to the rules? Because even after 30 years of doing it, I still like to go into every trial assuming I know nothing, that it's my first trial, the first time I'm doing it, and I don't want to take anything for granted. And the reality is I could probably do a trial in my sleep, and I don't want to ever do one in my sleep. As a judge, I have to always be aware of the fact that I'm the one who's overseeing the process. So if I don't know what the process is, it's not going to be a very fair or productive trial. So pulling out the rules, taking a little bit of time just to refresh your memory about how is this going to work from a technical point of view is a good way to start preparing. And I think that's a good way even as a lawyer. It doesn't matter if you're prosecution, defense, plaintiff, defense. It's always good to start from the premise that you don't know everything. It's a good practice to refresh your memory and don't take it for granted, because you're less likely to miss something important if you do it that way.
Now, staying with preparation here, and I think with mock trials, obviously it's a little bit different. You have these very long, complex fact situations, and you're kind of parsing through, similar to maybe disclosure. I mean, David, if you can read the officer's handwriting there, I mean, got to get the notes typed or something. At least there's an advantage here with the notes being legible. But in terms of maybe, let's start with you, Iseult, in terms of making those preparations where now you want to organize your thoughts or by witness or maybe exhibits you're looking to be introducing. What's a good way for these students when they go into a mock trial here, their first sort of experience in terms of organizing everything and making sure it runs smoothly, especially in light of the fact that it's going to be done remotely?
Remotely. So I've run a lot of things remotely. It's never better than in person. The moment technology is involved, everything just goes sideways. Today I was running a preliminary inquiry, and we didn't get started until I think noon because the router had gone out for several of the buildings and our child witness couldn't appear. So remotely is difficult. Number one rule with remotely is to check all of your electronics in advance. It'll be a little easier for all of you since you'll be doing this and other people will be in charge, but double check your video, double check your sound, maybe Zoom call someone to make sure there's nothing offensive visible from the screen. And then in terms of your actual materials, for minor offenses, usually what we'll do and where we're calling like maybe one or two witnesses, I'll have just like a little piece of paper where I've written out kind of my main things I want to know. So I'll write like who is the accused and what are the offenses and what are the dates of everything. And then who are the people I'm calling and where am I trying to go? That's for something that's going to take maybe a day. Since this is something you want to take very seriously, you're going to make what is called a binder. trial binder. So you start with, you have a cover page that looks like that, where you should have like a little outline of, who is this, at the top, what did they do? What's the main thing you're trying to prove? Like often they use murder, for example. So it'd be like murder committed on January 13th, 2021 or whatever. And that who they killed and what's the basic theory of the Crown and who are the witnesses that are being called. The next thing you do is you have sort of subsections. So, and you should put everything in order of when you're using it from beginning to end. And then I like to color code. So when I started as a Crown, I went out to Staples and I bought like little plastic sheets that have little colored edges on the side. And I use like red for exhibits and yellow for documents that I need to keep track of. And plain is for my notes and blue is for officers for obvious reasons. So I organize it that way and I put it in sequence of when I'm calling people, and then I have little tabs for when I switch. So you want to go from the first set of notes to the next. You can do it electronically as well, but you just make folders and you have like a main folder where you have your subfolders, and then you go into each one as you go through the trial. You want to put everything in order. So on a computer, I just change the names of the folders to numbers, and I'd be like 1, 2, 3, 4, 5, 6. In terms of the order in which I'm doing things. And then I just keep updating that main document where I have a little overview of everything. And that's sort of my cheat sheet as I go through and move things around. And then I change the numbers as I add people in. And then you organize your witnesses in that sequence. And then you have your exhibits in between. So I would have like, here are my questions for the first witness I'm in chiefing. And then behind that is the exhibits I need to put to them. And for really complicated cases, I'll actually put the exhibits in between where I'm asking the questions, so that I don't miss anything. And I usually do like, you're gonna cover sections like Dave was saying, there's sort of things you wanna get out of each person. So for each section, I do a page. And then I do a new page, whether it's electronic or print, where I write a topic at the top and then little points I need to get to. Cross-examination is a little different because you usually, especially as a Crown, you kind of have to roll with the punches because you have no idea what people are gonna say. So they just speak and then you're like, okay, I guess I'll ask you this now. So I keep that a little more like the skeleton Dave described, but I usually have just one page with the main topics. And if I have like a statement or something to work with, then you would do like the same thing, topic at the top and then questions. That would be my recommendation.
All right, David, over to you. I know you mentioned a bit of this in your last answer there, but anything more you can share in terms of preparing, especially in like I said, if it being remote, how do you set up your exhibits and your documents? Do you have any sort of technique there to break through, as Iseult pointed out, that potential for technology to unravel everything?
Yeah, so for me, I'm very comfortable with technology, so I would prefer to have everything digital, but you have a sort of a limitation with screen real estate when you're especially over Zoom. It's not as bad in person because you have your entire computer to yourself, but with Zoom you have some amount of the screen taken up, and maybe ideally all of the screen taken up with the witness that you're dealing with. And in some ways that's good, right? Because when you call an officer racist in person, you're so far away. But in Zoom, it's like you're right up against the person's face, right? And all those little expressions that those little micro expressions on someone's face when they're called racist is really lovely when their face is all blown up on a screen and everybody's watching. So there are some nice advantages for the defense over Zoom, but it does mean your screen real estate is significantly reduced. Even if you have two monitors, one of them is probably completely taken up by Zoom. So what I do is I do a kind of a hybrid, a bit of a blend of things that are going to be on my screen versus things that I'm going to print out. So for sure, anything that I want to be able to screen share as an exhibit, that's something that's going to be on my screen. But if I want to play, say, a video and it's a lengthy video, but I want to only play certain timings, I may print out the timings and keep that as a printed document for myself so I can just refer to it easily. If I have sections of the law, for example, or case law, I may print those things out just because they're very quick references. So you got to think about how you're actually going to run the trial and how you're going to flip back and forth between material you need to access quickly and the limited screen real estate you have. And so some of that is going to dictate what gets printed and what doesn't. But one rule of thumb that I use is if I'm going to want to make notes on it, and I guess this depends on how you make notes, but I'm for the most part, pretty quick at making digital notes. So things that I want to edit and change around, that stuff is all going to be online for me. And things that's going to remain completely static and unchanged, I can print those things and keep them on my desk with me. So that's one thing. For me, I like to try to keep almost a transcript of the Crown's witnesses. So the Crown's questions and what these witnesses say. So I will try to type verbatim exactly what's going on, because it's always a miserable experience to tell some witness they said this, and then to have the judge disagree with you and then play it back and they're right and you're wrong. So it's lovely to be able to tell a witness they said this and have a judge tell you you're wrong and have them play it back and then you're right. That's a wonderful experience. So if you have it written down verbatim, you're always going to be right? So you make sure you take really, really diligent notes, whether it's by hand or by computer, however you can do it the fastest. And then what I also do is I do it digitally, but I will generally have 2 columns set up for each Crown witness, a big table with 2 columns set up. One column, like the left-hand column for me, is my transcript of everything that's being said. So I just type a Q for question and I write out the question the Crown's asking, then hit enter, then I put an A for answer and I write out the answer. So I just have this big QA list going down. And then on the right-hand column, I'll make notes to myself. So if I really want to, sometimes I don't have enough time and I'll just highlight something, but sometimes I go back and look at these highlights and I think to myself, why was that highlighted? I don't know why I highlighted that. It's not obvious to me anymore, right? So I try to go in the right-hand column and make a note about what I've highlighted to tell myself, this is an important area for cross-examination. Ask this, or what about this? Or this is in conflict with this piece of evidence over here. So that's how I try to do it. I try to keep a transcript on the left, and I don't know if you guys are in pairs or if you guys are sort of in pairs or groups, or if you're just individually doing this moot. But if you have a partner, that's a great thing to do, is maybe one of you can be a transcript person, and if you have a thought while you're transcribing, you can just quickly whisper it over to your partner and they can take the cross-examination notes. But that's going to be a key thing, because you're going to have what your plan is for your cross-examination, but you're also going to have a lot of interesting things that come out in the Crown's examination in chief that you're going to want to incorporate into your cross-examination.
Right, and Robert, there, either from your experience practicing or your experience as a judge there, any other tips there in terms of preparation for for trial?
Well, I think what I've heard from both David and Isolde are excellent points, because from a judge's perspective, when the counsel appearing in front of you are prepared in the sense of having, number one, a roadmap, whether it's a skeleton outline, a well-organized binder, or whatever, that helps the judge. Because what we get this free flow of information coming at us, and we don't always know what it is. As much as you get a file ahead of time, exhibits come up during a trial that we haven't seen before, argument comes up that we haven't heard before, and we just get this whole barrage of information at us, and we have to try to keep it straight. And if the counsel can't keep it straight, then we certainly can't. It's like getting 100 numbers, but not in order, 1 through 100. And then we're expected to remember, oh yeah, 75 came after 3, but it came before 2, and then it came after 56, and it makes no sense to us. So what Isolde and David are doing will make for a really good trial, because the information will come out with some sense of order. Because what I do as a judge when I'm taking notes, I do something very similar to what David does. I take down almost a verbatim transcript of what's being said at trial, because I know as a judge, I have the exhibits available to me. They're going to be giving me the paper or online, the files, so I don't have to worry about exhibits. But what I will note is, let's say exhibit 3 is a copy of a check that is allegedly forged. So I'll mark down exhibit 3, check dated November 2nd, 2018. And then on the column to the right, I will highlight if it's something that I think is important, but I'll write a note and I'll say, but note that the way the letter T is written is very different from the way the sample of the signature on the other documents is presented, so that I remember down the road, and it could be a week later that I'm writing a decision, or it could be a month later. Why did I highlight this exhibit as being important? I know everyone's saying it's forged, but why? I'll make the note. Someone brought up sample of handwriting, the letter T looks different. That's key for me. And if counsel can point those things out to me, then I can make that note. And I'll do the same thing with the evidence that people are giving. I'll take notes and I'll highlight questions in my mind. And when you're appearing in front of a judge, the one thing you always have to remember is that as much as judges are supposed to be neutral, judges were trained as lawyers and their instincts are to be advocates. And judges will hinge, they'll pick up on something and say, that's the key to it. This is why my decision will be a certain way. And the judge will look for the evidence and everything that they have to justify their decision. So when I'm writing my notes, I'm very aware of the fact that I write questions and I'll say, but so-and-so can't be true if this is also true. So I'm questioning the evidence as if I were cross-examining the witness, because when I'm writing my decision, I then have to justify my decision. So I have to be able to say, I find that the check is not a forgery. Why? Well, evidence from witness number 3 was suspect because they admitted that when they saw this happen, they were drunk. Or they admitted that they were in a different room when they heard the conversation and they heard it through the walls and they couldn't be sure about certain things. So never fool yourself into thinking that the judge is completely passive. The judge usually is even more active than the lawyers in terms of hearing the evidence and cross-examining in their own mind and scrutinizing it. So when you're preparing, be prepared to treat the judge as an active participant in the case. They're not just sitting there watching television for 5 hours and at the end of it giving their opinion, yeah, I thought it was a good movie. They're actually throughout the movie saying, yeah, that scene, that's not believable, or that actor, that actress, absolutely the worst performance I've seen, and this is why.
Now, speaking of performances and the best and worst performances, the first time now when the trial starts, at least in the mock trial, not in every area of law, you have an opportunity for an opening statement. Now, Esau, maybe you can start telling us what would you want, certainly if it's a jury trial, you're talking to the jury there, but in an opening statement, what do you want to convey? And as well, I think maybe a good point here to talk to the students about the burden of proof on the Crown's part, what you have to do. And then certainly when I go to David, we'll look at it from the defense perspective. But what are you hoping to accomplish in your opening statement?
So opening statements are all about grabbing the attention of the people you're talking to. So the number one question to be asking yourself at every moment when you are running this trial is, where am I going? Right? Where am I going with this? Why am I doing this? You could write the most beautiful cross-examination question in the world, but if it serves no purpose, why would you ask it? Right? And the goal is to convince, essentially Robert, that this is what happened. And the Crown holds the burden of proof. So, going back to our original answers of the first question, the first thing I look at is, what evidence do I need to establish my case, right? And the first thing Dave looks at is, where can I poke some holes here? So when you're thinking as the Crown, it's your job to put the evidence before the court. And you represent the public. You're a minister of justice. It's your job to do what is right, not just what will get you to win. So you have to look at it very ethically, but you also have to ask yourself, what am I trying to show here? And there is always kind of a key to the trial. There's a little piece that's kind of central that sort of tells you which way it's going to go. And usually with the mock trials that I've been a part of, there's some sort of little piece of evidence in the fact scenario, and how that evidence comes out really decides everything, right? Because they try to pick things that are borderline. So your job when you're trying to prove things beyond a reasonable doubt means that you have to show that there is no doubt. It's a very high standard. It's, mathematically they talk about it like 95 to 99% certainty. So you really need to convince this person that this happened. So when you get up and you're speaking and you're about to let fly all the numbers of 1 through 100 that Robert was talking about, you need to ask yourself, how am I going to keep this person entertained and wanting to listen to me and believing what I'm saying and the things that I'm presenting? So you want to find that key to the case, that central piece, and you want to start with that and you want to end with that, bring it full circle. So one of my colleagues does a thing where he picks a quote from the witness's evidence and he actually says it to the jury, which is extremely traumatic and is an option. But the point is that he's very convincing in jury trials because he has got their attention, right? Generally, whoever's sitting there has no idea what's going on, no idea what the facts are you're about to present. So when you get up, the purpose of that is to say, if it's a jury, right, here's kind of what's going to happen today, because they don't know. And also, here's who I am, here's who all these people are, here's why we're here, and this is why you should care about this. So find your message, find your theme, and set it out at the beginning. And then everything you do from then on is to come back to that theme, which can vary depending on what the case is. But that's always anytime I've ever given an opening statement, I give opening statements to judges so that I can practice. I don't just do them in front of juries. And I always try to ask myself this question, because every senior person I've ever asked, whenever I tell them, like, here's what I'm thinking of saying, they're like, well, they ask me, well, what's the theme? What's the point of this trial? Why do we care, right? So ask yourself that same question, and then you can find your little key to the story.
All right, now over to you, David. They're now looking from the defense perspective, where you don't have to, I think this is when at least when I was in high school, to grasp, well, hey, you just have to raise reasonable doubt. How is that different than, in a civil matter where it's, on a balance of probabilities? What do you do differently than in your opening statement than what Iseult said? And you got the benefit of speaking right after. Do you immediately respond to stuff that's come up there, or do you have sort of your own structure, your own theme that you want to tell from your theory of the case?
Right. So on at least in criminal law, on the defense side of things, typically the opening comes after the Crown has closed their case. So you'll get a chance to open as your case is starting. It doesn't always have to go that way, but that's kind of the normal way that it goes. So one thing that I discovered after becoming a lawyer is that people are very interested in you if your profession is law, but they immediately find themselves hating you if they find out that the particular area of law you practice is criminal defense law. So one thing that people say very regularly is, oh my goodness, I can't believe you can defend people like that, or how could you defend people like that? So I think criminal lawyers generally are under the impression that most people sitting on that jury panel probably think they're the scum of the earth. And so one thing you can at least try to do in your jury address is just be nice, be likable, right? This is the first time really the jury is going to get to hear from you, except for previously when you're cross-examining people and trying to make them look like liars, which it's not a great introduction to the jury, right? So your opening statement is a chance for them to get to know who you are. But you should, at that point, already know what's going to go on with your case. You'll know if your client is going to take the stand or not. And so it's a great way to introduce them to your client as well, and just share a little bit about your client and what you're expecting them to hear from him or her. And so, for example, like in a murder case, I think you guys are doing a murder case, is that right? Yeah, like in a murder case, we always think, like, if you're sitting there on the jury and you're seeing somebody being accused of murder, like, wouldn't everybody want to know what that person has to say about the murder, right? So we always think, like, how can that person not take the stand, right? Everybody in that jury is wanting to hear from that person. And so it's great to be able to tell them. And I think there's a common understanding that lawyers don't often put their clients on the stand. So it's great to be able to tell these jurors, look, he wants to get a chance to take the stand. You've heard from the Crown, and all you've heard is the state, the powerful state, trying to show that my client is guilty. But, you know, little old innocent guy over there, he wants a chance to be able to speak on his own behalf. He wants to be able to tell you guys all that happened. And so you want to make your guy look like a nice, wonderful person, and he's going to take the stand and share about all the things that have happened. And so another thing that Esau talked about is a theme. And maybe before you can even get a theme, you need to really make sure you know what your theory of the case is. I remember when I was in law school, I don't know if we had this class together, Esau or not, because we went to law school together, but my evidence professor said, having two theories of the case doesn't give you two ways to win. It only gives you two ways to lose. So it's a very good point. You know, if you have two theories of the case, it's a very confusing thing to put before a jury. My guy didn't kill this person, but if he did it in self-defense. It's not a great way to put your defense to a jury, right? So you really want to make sure you're very clear on what your theory of the case is and what evidence you're going to be bringing out in your case. And then that stuff can be worked into your opening statement, what you're expecting the jury to hear and how that, and so you want to make sure that you've got the pieces of evidence that are really going to support your theory of the case, and that those are the things you'll tell the jury they're expected to hear. So I think it's a great way to introduce yourself, introduce your client, and then introduce your theory of the case.
And Robert, what are you looking for? You know, and I know it doesn't always happen in small claims court there. Well, what do you want to hear there at the beginning from both the plaintiff and the defense counsel?
Well, the first thing I don't want is I don't want the trial given to me in the opening statement. And that's, I call it a rookie mistake, when people come in front of me and they figure, this is my chance to talk to the judge. I'm going to tell the judge everything they need to know. And it's like, no, that's what the trial is for. That's what the witnesses are there for. If you could tell me everything, we could shorten the trial. We do it in 15 minutes. You could just give me your summary of it and I'll make the decision. And we know how fast divisional court or the Court of Appeal would jump on me if I allowed a trial to happen that way. No witnesses, just opening statements from the lawyers. So a lot of lawyers, when they come in front of me, think they need to tell me every single detail. And I tell people, you know, when we, before you get to a trial, and it's the same thing in the criminal world, you will have a conference with the other side in front of a judge. In civil cases, in small claims, it's called a settlement conference. I tell everyone who's in front of me, and it doesn't matter if they're people acting on their own behalf or if they're lawyers who've been practicing for 60 years. I said, treat the judge like they know nothing. Treat them like an idiot. Treat them with respectful idiot. So treat them with respect, but pretend that they know nothing. And that should govern how your opening statement will work. If they know nothing, you're going to overwhelm them if you give them every little detail. So give them an overview. Educate the judge a little bit. Say, you know, first of all, it's your only chance to really speak to the judge without showing your legal skills. Because the rest of the trial, you're examining, you're cross-examining, you're making legal arguments. In an opening statement, you get to talk one-on-one either with the judge or to the jury, and it doesn't have to be in technical terms. It can be as simple as, Your Honor, this is a very simple case. This is a case of Mr. Jones wanted a new driveway, and his sister-in-law knew this guy who did driveways. So he trusted them. They came in, put in the new driveway, and unfortunately, 2 days after they finished work, the entire front of their house collapsed because it turns out that they dug under the foundation when they were doing the driveway repair. And you put it in layperson's terms and say, that isn't something anyone expects to happen, and it should never have happened. Now, in saying something like that, has nothing to do with law, has nothing to do with technical arguments. It's basically giving the judge the simplest, very simple outline of what's going to happen. And then you might say a couple of words and say, look, I anticipate you're going to hear from Mr. Jones, that this is true. And from the sister-in-law or from the, give a very short outline. The longer you talk, the more you're going to lose your audience. And also the more of a target you become to poke holes in it. Because the judge may not remember anything other than when you said in your opening, and I promise you, Your Honor, you're going to hear from this witness, and it's a solid alibi. And if that witness turns out to be a complete dud, the judge is going to remember your opening and the promise you made. They're going to remember the witness and say, how do I believe anything this lawyer says? They built this all up and they lost all their credibility in that one moment. So don't give them anything that they can attack. Give them something that they can relate to. Make it idiot proof so that even the judge will understand it. Because if the judge can understand it, the jury can. Because the jury is usually more interested than the judge. The jury, for them, it's a novelty. For a judge, it could be their 3,000th trial. That's the way I see it, at least. And, you know, it's the KISS principle, keep it simple. And if you keep it simple, you're going to make it easy for yourself. Because if you keep it simple, you'll understand it too, and you'll be able to stick to your plan a lot easier than if it's 1,000 points long and it looks like you've just programmed, you know, a computer simulation of a space flight with 5,000 lines of code. If it's that complicated, no one will understand it.
Right. So I'll end here with one question each for all of you, and then we'll turn it over for the students to ask any questions. So I'll give you, Iseult, then the direct examination. What are you hoping to get out of your, your police officer, the officer in charge there, or civilian witnesses? Any sort of tips there in terms of going through direct examination? I know we've talked about preparation, but the actual delivery of your direct.
The most important thing with examination in chief is to know, again, where you're going. Like Robert was saying, he's hearing all this for the first time, and whatever his previous experience may be, he knows nothing about this case. And he's your audience. He's the person you're trying to persuade. He's the only person in the room that really matters. So the questions need to be formed in a way that tells the story. So for the Crown, we're always trying to tell a story, right? Stories are persuasive. So you're trying to set out your whole tale, and you want to have a beginning and a middle and an end, and you want it to have a theme. And that should be the case of your direct examination. So when you're looking at the witness's notes or their statement, often they will have things out of order. They'll go back and add information. You have the advantage of having already had this person be interviewed by someone else who didn't know the story. They were just hearing it all for the first time. And you get to take all the little details and put them in an order and create that story. And then once you have your story set out, you set your questions to go through it. And you start with little pieces. And that's what I was talking about earlier with those pages. I have my story into like usually 5 pieces. And this is part number 1. And then I talk about part number 2. So if it's a murder and someone witnessed something, let's say, part number 1 is I saw Greg earlier in the day. And then part number 2 is, this is where we keep the knives. And part number 3 is this is when I saw him with the knife, right? And it comes together. So that's the most important thing to remember, is the story you're trying to tell. With the questions that you're choosing, you want to keep them open-ended. Open-ended questions, it seems, is a thing that people struggle with. It's certainly a weird thing to get used to. But the key thing is just to choose questions that don't have the answer in them. But because you know what they've already said, you know what they will say. So you want to choose your words carefully to trigger the part of their brain that will respond to what you're saying. Since it's a mock trial, I believe that, at least in the ones I've done, you actually work with the witness and you're all on the same team, right? So don't overscript it on either side is my main advice to you. Don't sit there and rehearse exactly what everyone's trying to say. Know your story if you're the witness, know your story if you're the examiner, and be responsive to the other person. The more responsive you are, the better the story comes out, and the better it is for Robert when he hears it all together, because now he can follow what it is that you're saying. which is really the most important thing. So that's essentially how I approach it. And the other thing is, whatever it is that is the key to your story, make sure you highlight that. Usually in the fact scenario, especially in a mock trial, there's a little detail that could kind of go either way, and that detail can really make a huge difference. I did one where this guy was pushed over a railing, and the issue was like, did he push or get tripped? And for some reason, the little detail leading up to like his footment placing was just disregarded by the Crown side, and so they lost. But because if they had gotten that piece out, it was obvious that he had to have been pushed. So go through it carefully, find your little details, highlight those details, and put them in your story in a way that makes sense and is easy to follow.
Thanks, Iseult. Now, David, you've heard Iseult deliver there, went through all of that. The officer gave these brilliant answers, and now you have the task to undermine and poke holes in that in your cross-examination. So what can you share for students in mock trials there when they're doing cross-examination in terms of just types of questions you ask and how to poke holes and attack the credibility or the inconsistency of maybe some statements made by the witness?
Sure. So there's a couple of things. I think Iseult already mentioned that as Crown Counsel, she doesn't really know what these witnesses are going to say, the defense witnesses. So she's cross-examining, having heard this stuff for the very first time. On the defense side, though, you have a real advantage because you've got the evidence in front of you already. So you don't have to prepare your cross-examination kind of on the fly like Iseult does. You can really spend time thinking about every piece of information you want to get out of somebody. And you can really spend time thinking about, like, what's the order that I want this information to come out in? What would be best? And you know for sure that some witnesses are just going to stick to their guns, even if what they're saying is true or not. But sometimes it can be very powerful to bring out some evidence about a particular witness right at the end. And so I had, for example, a woman who she was watching a security. She was in a police interview, and she was a Crown witness, so she was giving this interview about what a terrible person my client was. And while she was giving this interview, she talked about seeing my client as less than human and believing my client was a crack addict. And she's talking about seeing her every day and knowing that she does crack. And my client does not do crack, and she looked a little disheveled for sure, but she cleans up very nicely for court. So when she was in court, she looked great, right? She was just a regular person. And so, we went through the whole cross-examination with this person talking about how my client had done these terrible things and she witnessed it all. And then the last thing we did, and I wanted this to be, and I don't know if you guys will get a chance to really think through this portion of it, but sometimes, if you know the court is going to break, you might want to leave the jury with an interesting piece of cross-examination just before the break or just before lunch or just before the end of the day. So what I did, I think the judge was a little frustrated at me for doing this, but I dragged my cross-examination out until the end of the day, probably an extra 45 minutes longer than it needed to be. And so it was a little bit of a frustrating end of the day, but I really wanted to start the next day with this police video. I didn't want her to have the chance to sort of know what was coming in this interview that she did. So I hit her the next day with this interview about all the terrible things she had said about my client, and my plan was to suggest to her that she was racist, but she actually picked up on that first, and she said, "Are you suggesting that I'm racist?" And I said, "Well, it's interesting you jumped to that conclusion." But so it was a really fun cross-examination. But that was one of those things you've got to sort of think about. When are you going to bring out those particular things? And so you need to be thinking about when or what order you're going to be doing things. And sometimes it's going to make sense to do it chronologically, but other times not so much. Like in my case, that police interview was probably the first piece of involvement that lady had. And so, but I brought it out at the end, right? And so, you gotta think through that sort of stuff, but you also should know what evidence you want to get out of each person. What are the points that you're trying to bring out? And then you want to make sure you're asking very direct questions. A lot of lawyers have a rule that says they're not going to ask a question that they don't already know the answer to. So you want to control the witness as best as you can, ask them yes or no questions, And you basically want to, some people talk about it as setting up these walls in a room where you sort of are setting up walls to trap somebody into something. So you want to make sure you ask them a series of questions first and you get all their answers, and then you close them in with that final wall. So you have to be careful the way you set up your questions and make sure that when you've got that question that you feel like you're going to nail them on, there isn't some way they can wiggle out of it by having some other answer. So before you sort of show them your final card, and this is the question that's really going to nail you, ask them a lot of easier questions first, ones that you're going to know the answer to, and that they're going to give you the evidence you want, and then you can hit them with that final question. So another thing we try not to do in a lot of cases is ask what some people call the ultimate question is. And you know, a lot of times you can't say to an officer, "You're lying, aren't you?" And the officer is going to say, "No, of course I'm not lying." You don't necessarily want to ask questions you know what the answer is going to be, but you're going to be stuck with that answer and you can't go anywhere with it. So you got to be careful about the kinds of questions you ask. But the key thing for you is you're in control. You control the witness. You ask them only yes or no questions, or questions that are very simple answers that you already know the answer to. And then you think about, what are the pieces of evidence I need to get out of each particular witness, and what's the best order to bring that evidence out. Sometimes the best order is a confusing order, just because it's nice to make sure the witness doesn't know what's coming next. So you don't necessarily want it to be chronological, but other times it's just it makes sense to go chronological. You don't want to confuse the witness to the point where they don't know what you're talking about anymore. So they still need to be able to answer your questions. So you just got to think about, what's the best order to bring all of this evidence out, and what's the best way to make sure that when I ask them a question, they're not going to be able to wiggle out of the answer. So you set up your questions really well with a bunch of questions beforehand.
All right, and Robert, the last thing here, it's closing time, right? And I think you were alluding to it before. You know, I think there's like that basic principle of public speaking. You know, in the opening, you tell them what you're going to say. You know, the evidence, you say it, and then in closing, you remind them of what you said. So, what do you look for in terms of in the closing, or are you kind of just wanting a summary there of what's been said, or reference to the law? What are you looking for in a closing, and how can an effective advocate deliver an effective closing for you?
Again, an effective closing for me is one that isn't going to put me to sleep. And again, a lot of lawyers make the mistake of rehashing the entire trial as if I haven't heard the last 6 hours of evidence. They're going to say, "Well, Your Honor, we're going to tell you what you've just heard over the last 6 hours." What I look for, and you know, I like the way David put it in terms of building the walls. When I was in law school, I learned a game called snooker. I'd never played pool in my life before. And that's what we did. A couple of us used to go to the graduate students club, and we played pool. And the whole idea of snooker is, when you set up your shots, you set up the shots so that the other side has no option to take any shots. You know, if they have to hit a solid versus a strike ball, you've set it up that they cannot make a shot. You've snookered them. And that's what I like to see in a closing. I like it when counsel are able to present something to me that has an unavoidable conclusion, that there's no way that the other side can wiggle out from that. And that could be the plaintiff saying, "Your Honor, you have to decide this way because," and then they give me the setup. They set up where the balls are located on the pool table in a way that I have no choice but to decide that way. That's what judges love. Judges love to be told that they don't have to exercise any judgment or discretion, that it's been set up for them. The worst is when you get these cases where it can hinge and go one way or the other. And as a judge, you actually have to make a decision. So it's really great if in your closing, you use tools like logic. You know, if the sky is blue and the murder weapon is blue, then the reason you couldn't see the murder weapon was because it blended in with the sky. You know, that's an oversimplification, but things like that. If A equals B and B equals C, then A equals C. And judges love that. Judges hate it if you say, well, A could be both B and C, but sometimes it's D. And you heard the witness of that, the evidence of that other witness. And yeah, it could be E, but you can rule out E. You don't want to hear that. So in your closing, if you can make it almost mathematical, logical, and inevitable, that's where you can win a case. Otherwise, you're leaving it to the discretion of the judge, and then you got a 50-50 chance. And I don't like those odds. 50-50 means I could lose. If I've covered every base as best as I can and made a good logical argument, the judge is going to have a hard time arguing with that. Even if they've got some doubts about little pieces, little details, just make it inevitable. And that's not always easy to do. But if you come across as believable when you're saying it, and a lot of it is theater. A lot of the times what you're saying has no basis in reality. It's a theory, and you're trying to convince the judge that that theory is logical and it makes sense. If you're believable, you have a good chance. If you look like you don't believe what you're saying, then why should the judge accept it? So there's a certain degree of confidence, bluffing, acting that goes into law. Because we all know there are a lot of people who are innocent who go to jail, and there are a lot of people who are guilty who walk, because sometimes the case just worked out that way. It has nothing to do sometimes with what the absolute truth is. It's who put on the better show and convinced the judge or the jury. And it's a sad thing to say that, because you like to believe in truth, but reality creeps in.
Perfect. So thank you all of you for joining us here. I want to just give the students, I know they might have some questions. I don't know if John, you want them to put into the chat, or if they want to unmute their microphone and ask. So if anyone has any questions, here's the time to get a chance to talk to either a Crown defense attorney or a judge. So I do see a question about precedents. Do you have a preference there? I guess any of you, quickly about, do you prefer like quick law or Canley or Westlaw, or anything like that?
Depends what your budget is. Canley is free. Quick law you have to pay for.
There's oh, sorry, go ahead, Robert.
So I mean, I use Canley as my first line, and if I find I can't find it there, then I go to quick law as a second line of research for case law. For precedents, what I do is if I find a lawyer who's argued a case similar to what I'm doing, I'll call up the lawyer and ask them, what did you put in? Where did you look? And you'll find that if you do end up in practice one day, lawyers can be fairly generous in sharing their information, as long as you're nice when you approach them and don't make it look like you expect them to do it.
I think since I represent the powerful state, as Dave put it, I have access to all the things. We're not really that powerful, but we do have all the subscriptions. So there's Westlaw, there's Quick Law, there's Canley. There's also, most, like Robert was saying, most lawyers kind of they speak to each other. I know the criminal defense bar has like materials they pass around. The Crown has something called eLibrary, which is a poorly named database where we sort of collect, what we call primers that set out a summary of an area of law. One of the first things I actually do, since especially if it's something totally new, which it would be to any of you, is I look for something that summarizes it. So there are a few things like that. There's the Criminal Law Notebook. It's a database that's kept up by a Crown, I think, in Nova Scotia. And so it typically has a bunch of sites of cases, and it's like Wikipedia, but for criminal law. The only thing is, it's obviously like Wikipedia for criminal law. So you can use the sites as a good place to find cases, but you can't rely on it for the truth of its contents. So I often start there and I'll look there, and there's something called Charterpedia, which is a website that's kept up by the government, which sets out these, summarizes like each of the charter sections. So if you get a case with the charter in it, that's a great place to go. Again, I wouldn't totally trust every word on it. There's definitely mistakes on there here and there, like when they summarize a particular case, but it has all the tests under each section, and then the key cases are all there. So you go from there to find your cases, and that gets you a little bit of information. On Westlaw and Quick Law, there's something called the CED, which stands for, I think, Canadian Encyclopedic Digests. And so that covers general topics of law. So that's another good place to try and get that information. So once you have like a sort of background, then you kind of know what cases you're looking at, and you can go into those cases and see what cases they cite and go from there, right? So that's generally how I approach it. And Canly is, although it is free, is actually quite good. It just doesn't have as sophisticated of a searching algorithm. If you have access to the other ones, I prefer Westlaw mostly because it's blue, and Quick Law has this offensive red color that's hard on the eyes. So.
Robert, anything different there that you've used? Oh, sorry, David, anything different that you've used?
No, not really. Like I find the criminal law notebook a pretty good place to start also, and it's great for getting a lot of the leading cases. I guess the only thing I would add is Canly, I think, is getting better and better all the time. And so one of the things that it feels new to me, but maybe I'm wrong, I just never noticed it before, is when you look up a case, there's often a tab called treatment where you can click and you can see how other cases have referenced that case and whether they've treated it well or not. But yeah, if you find a case on Criminal Law Notebook, you can always put it into Canly, and then you can click that treatment tab, and so you can find other cases that have spoken about a similar issue. So it's often like taking a lot of these tools and using them together that is really, really helpful. You probably aren't going to find a single tool that is your be-all for everything, but using a couple of them together, and often a lot of criminal defense lawyers have pretty good websites that give you some very basics. They're not citing case law and all of that, but they're giving you some of the basics of the law. That's how some of these guys promote themselves. And so that's often a place where you can read some interesting information. But yeah, I really like criminal law notebook. I think it's very well laid out and it's very clear. And you have to check the sources and all of that and read up on the case law yourself. But it's a pretty good place to start, though.
Yeah, and certainly I think for your mock trials, if you just want to look up the sections of murder and what you need to, I think it lays out the elements of the offense, which is if you're the Crown, you got to prove all of those things. It's a great resource for you. So I put in those links there. Thanks, Isel, for sharing. And as well as for Canly and Canly Connects. You can also look for opinions. There's other websites there with respect to scholarly articles about cases. So if you want to know more about the case, you don't quite understand it, they break it down. And the Ontario Justice Education Network, OJIN, has a lot of stuff as well for geared towards high school students. So I think you can use that as a good resource as well to add. Are there any other questions? John, did you get any questions directly? And thank you, Anna, for that question.
Well, I see one more in the chat there, JP.
I don't. Maybe I'm missing it. Maybe it was just to you, or
maybe I'm lying to you. It was a direct message, so I guess that wasn't intended for everybody.
Sorry, there is a question for me. How do you go about proving beyond a reasonable doubt and protecting yourself against defense poking holes? So, beyond a reasonable doubt. I mean, you do the number one thing is the actual evidence for the Crown. So you can put on as much of a show as you like when you're defense counsel. The benefit of being defense counsel is that you come in, you run your matter, and then you leave. When you are the Crown, you're there all day with the judge. So if you say something ridiculous, you'll be reminded of it. So we generally have to mind our P's and Q's a little bit more. But the number one thing is the evidence. It always comes back to that. So that's where I really try to look for the thing that, like Robert was saying, is like an unavoidable truth. Like, how can this thing be true if this other thing isn't true? One of the hardest cases to prove, and which I unfortunately prosecute a lot of, are historical child sexual offenses. And one of the best things that we get are always if they at a certain age talked about something that no child could possibly know about, and there was no other way for them to have gotten it. So even though I can't like go back in time and get DNA and everything, I have this thing that has no other explanation. There is only one explanation, and is that they're telling the truth. So you try to find that piece that is like your shield against the little sword that Dave's going to try and poke the holes with. And you want to also look for what the holes are. So if you get too up in your own head about like, obviously this is a slam dunk, clearly this happened, right? That's where you start to lose touch. You have to always ask yourself, did this happen? Like, did this person actually do this? Am I sure? Because we want to avoid this reality Robert has described where people go to jail that didn't do things. There's a sort of thing in criminal law we talk about where 100 guilty people should go free before one innocent man goes to jail. So that's how the justice system is structured. It's all structured around the accused. So you need to go in a doubt, and you have to be convinced by the stuff that you read that this happened. If you go in saying, oh, he's charged with this assault, he totally did it, you will miss the problems in your case. So you look at the problems and then you look at how to confront them. So with the historical case, it's like this happened a long time ago. People's memories fade over time, and I have nothing to corroborate it because it happened so long ago. I can't be like ask people where they were yesterday like I can with other things, right? Because it's so long ago, you know, people aren't going to remember where they were or what they were doing or what was going on. So you have to find the thing that helps you, that protects you, your little shield, and go from there. But the key thing is to stick to what you actually can prove and what you actually can admit. And sometimes it does happen where there are things that would definitely prove this that you can never put into evidence. And those are the worst cases. But there are things that you can't ask and things that you can't say. So you need to ask yourself, in law, what can I actually prove? And try to avoid getting hung up on what actually happened, which sounds crazy, but you're going to talk to your witnesses, right? In real life, I meet with these people and they come and they tell me and they cry and they try to hug me, you know? So I have to hear their stories and their realities. It's hard not to feel convinced by that, but many times there's nothing I can really do. So I have to ask myself, what can I actually prove? Because at the end of the day, I serve the master that is the law, and I have to do the thing that is right for that and stay within the bounds of the law. Otherwise, there is no justice.
Thanks again for that question, Annie. Maybe last question here for anyone. Maybe someone wants to put up their hand, unmute, and ask it themselves. Any brave high school students?
Don't be shy. We're very nice people.
Well, speak for yourself.
Okay, we're pretending to be very nice people.
I'll add in that I took law in high school, never thinking I would be a lawyer. And I kept my notes, and I think I took it grade 10 or 11. And this was back in prehistoric times. I made it to law school, let's say a decade later, and I still had my notes. And I would say the first 3 months of law school were almost word for word what I had learned in high school. And I was able to actually use my high school notes to get through my first year of law school. So anyone who ever thinks that a high school law class, any of this doesn't help, has never been through that experience. There's a half dozen technical things I never would have understood without having done it in high school and being able to look at my notes. And I was really surprised looking backwards just how sophisticated the education was in high school. So there's a lot to be said for it. And that's why evenings like this actually mean a lot to me, because it's a way of looking back at how useful it was. It didn't convince me to become a lawyer, but it helped me when I did accidentally fall into law school.
Yeah, I think I read the Oakes test in high school, and still, you know, now I'm on the other side teaching students the Oakes test. And I'm like, you know what, that the way we learned it was so, you know, easy to understand that it's a great way to turn it back and help anyone that's wanting to learn about the justice system.
I guess you're younger than me, because when I went to high school, we didn't have a charter, so there was no Oaks test.
I didn't want to say it, so but anything else from anyone? And of course, I mean, experiences like this and why, and thanks to John for getting me involved here, is that you get a chance to really put all of this together. I think as much as you learn. Oh, there is a question here.
I have a question.
Adrian.
Oh, hi. So, hi, I'm a grade 11 high school student, and I just finished my law class from the first term. So, I have a specific question that is non-related to this mock trial for you guys. So I was doing this project for my civil law unit, and it was my portfolio project. So I was just wondering, what do you guys think about not being able to hire a lawyer in civil cases? Does that hinder justice? What are your guys' thoughts on that? Not being able to hire a lawyer, and how some people are not qualified for legal aid, and is this fair for them? What are your guys' thoughts?
Okay, so maybe Robert, from the civil perspective, I mean, seeing self-represented and unrepresented parties in court there, maybe you can tackle that point. And then certainly, with legal aid certificates and all that in the news there from the defense side and the Crown side as well there, we can look at it from the criminal's perspective right after.
Well, I guess in the civil perspective, the problem is people, with criminal, it's easy because something happens, the state gets involved. The police arrest someone, charge someone, the Crown gets it to prosecute. And in a lot of cases, people, if they need a lawyer, will get it either through legal aid or somehow. In the civil system, it's actually the people involved who take the initiative. So if you're a person who's being sued and you can't afford a lawyer, what do? Your choices are just to sit back and do nothing, and you'll end up with a judgment against you, or you fight as best as you can. You see that mostly in the small claims environment, because once people start suing for $50,000, $100,000, $1 million, they're usually in the stratosphere where they get lawyers involved. Look, for the 15 years I've been sitting as a judge, I'm always aware of the fact that I can't take someone's side in the case, but I do my best in court to make sure that people who are without lawyers understand everything that's going on. And it makes justice take longer, but I don't see any other way around it from the court perspective. If you allow a trial to go ahead and you just know that one side or the other doesn't understand what's going on, and it's usually the defendant. If it's a plaintiff, they're the ones who are bringing the case. So they've got the burden, and they've got a burden to come to court prepared. If you're the one being targeted by a lawsuit and you're there maybe for no good reason other than someone's got a grudge against you, as a judge, you really want to make sure that the process is, step by step explained, and you'll say, okay, Mr. or Ms. Smith, Mr. Singh, this is the part where you have to tell your story. You're allowed to ask questions of these people, and you explain it. But I'd be lying if I didn't say that it is imperfect and that some people end up on the losing end because they know what to do. And I don't know what the answer is, because the government does not give out legal aid certificates for the most part in civil. I don't know if they do anymore. 30 years ago, you could in limited cases. Today, I doubt it. So if you can't afford a lawyer, or you choose not to go with a lawyer, and it's a complicated issue, you're at a disadvantage, and there's no other way to put it. Because you just may not have the skills or the knowledge to know that the plaintiff, let's say, has to prove 3 things, and if they don't do it, they should lose. But if you don't have that background yourself, how do you point that out to the judge? So it's a balancing act for judges to help without taking sides.
And David or Isolt, anything from the criminal perspective, with legal aid? As Robert said, it's not like everyone's getting legal aid certificates as well, right? So what do you do when you're having people who may need that assistance in terms of access to justice? What can we do in terms of the criminal system?
Really curious to hear Isolt's answers to this, because on the criminal side of life, legal aid, they won't issue a certificate to somebody if they make a certain amount of money, or if the Crown is not seeking jail time. So you could be completely impoverished, but if the Crown is not looking for you to go to jail, legal aid won't issue you a certificate. So I'm curious to hear Isolt's answer, because I've had certain Crowns. What you normally get is one of the very first pieces of disclosure you get is something called a Crown screening form, or a charge screening form. And on that charge screening form, it lists what the Crown's basic position is on it. They've screened it for jail time or some kind of a fine or whatever it is the Crown wants. So I've definitely had some Crowns who have screened charges for jail time and then said to me, I have no intention of seeking jail time in this. I just screened it for jail so that this person can get a legal aid certificate so that I get to deal with you and don't have to deal with that person. So I do find, I'm very curious to hear what Isolt's perspective is on that. Maybe she can't say, I'm not sure. But on the defense side, this is really tricky, because I really think lawyers are some of the most advantaged people around. And so I think lawyers ought to be doing some pro bono work in their practices. But it's actually, I've discovered it's really tricky to do pro bono work, because you end up with people who haven't paid for anything. And when you get something for free, you often don't value it. And so you end up in very strange situations when you offer pro bono services to people. And you can often do a lot of work to get them a really great outcome, only to have them reject it and do something terribly stupid in the end. And you sort of wish, and terribly stupid, but something that might be terribly expensive too, had they been paying for it. And you sort of think, if this person, if I charge them $40,000 for this thing they want to do, maybe they would not do it, and they would have accepted the really great outcome. So sometimes offering something to someone for free actually makes them select a poorer option for themselves, which is a very frustrating thing. So there isn't a clear answer to me. I think legal aid should be better funded. I do think lawyers should provide pro bono services, but I don't think that's some answer to everything. I think it creates its own challenges when you do that as well.
And of course, not just funding those certificates to get them to plead guilty, right? That are just come out there.
That's
So
a hot item these days, yeah.
Isolt, you get the last word there on this. So what do you have to say?
Well, just to the point of the legal aid certificates, I don't think there are definitely some lawyers who do a lot of pleas, but if you actually know how the funding structure works, you get paid so much more for a trial. So a plea is a flat fee, and so is a withdrawal. So I don't think that anyone's encouraging those outcomes if they can avoid them for monetary reasons. I can neither confirm nor deny what Dave alleges the Crown Office does sometimes. But I can say this, it is very difficult to have to deal with a self-represented person. We call them self-rep trials, and it's sort of like a badge of honor if you prosecute one. I had a shooting self-rep trial in the Superior Court that I was flung into, and it was something. He was actually a very articulate gentleman, but the problem you run into is they don't know the law, they don't have the experience, so you have to spend all this time explaining things. So even if you're trying to be extremely judicious, as the Crown, you're doing like 3 jobs. So you're trying to prosecute this person, but at the same time, you're like, let's make sure that their rights are protected. It's really hard for the judge because they don't want to veer into actually, being this person's lawyer. But then again, like Robert said, they are all originally lawyers, so it's an easy impulse to give into. And then it becomes even worse for the Crown, because now this person, previously the judge, this person's lawyer was, Dave, and now this person's lawyer is whoever sits on the Superior Court of Justice and has 35 years of experience. And trust me, you cannot compete with that. So it really is not fun if they take their side. And if they don't, then you're in this weird, awkward position of trying to defend the person you're prosecuting. So nobody wants that. It's great to have someone who knows what they're doing. Law is sort of this kind of human thing, and it's all about what's logical and makes sense in certain ways, especially criminal law. It has set rules, but it does involve a lot of technical things, and a lot of people who are prosecuted, like from the criminal law side, they're not very advantaged. They don't tend to be educated. They often have mental health issues. It's something like 85% of people in custody right now have mental health issues. That's just a rough number, but it's astronomical. So these are not people that are really in a position to be defending themselves on the worst day of their lives. So it's not good for them. It's not good for me. It's not good for the witnesses. We have to get orders made to have other lawyers come in and cross-examine people in interpersonal cases, but no one who's really been a victim of a crime wants to be asked questions by the person who did this to them. And then you also run into this weird situation where there's like an issue about the identity of the accused, and they're like asking questions about themselves in the third person, but they can't ask them in the first person because that would give away that it was them. So it's just a mess. It's awful. It's not fair. And so we really do prefer to have a lawyer. Unfortunately, legal aid can't afford to give everyone a lawyer. And the Crown can't take the position that they have to. Usually when someone brings an order to get, like for example, youth can get a special order to get a lawyer appointed. We just take no position. And that's kind of what we have to do because we're sort of caught between two roles at all times. But we definitely prefer it. And I really do think that everything goes better with it for everyone involved. In civil law, I don't have that much experience in it, but when I was in law school, I had friends who were working in it, and they would, they were students, so they would help people who didn't have any legal help. And the stories they would tell me were crazy because maybe, in small claims court where it most often happens, there isn't that much money at stake to you or I, but to this person, I mean, this is their whole life. Their whole life is completely upended over $1,000. So it can be really important then too.
And I'll just add, in the civil side, there's one other option, and it's called a paralegal. And a lot of people don't consider it as a real profession. I do, and I have in small claims court a lot of people appearing in front of me who are paralegals, and it doesn't require going to law school. It's a different education altogether, usually in a college setting. And it's a diploma program, and you are still licensed by the Law Society. Some people call them lesser than lawyers. I don't. It's a different discipline. But for a lot of people who can't afford a lawyer, paralegals are often a little more economical, and they allow a person who might not be able to afford a lawyer to have the benefit of someone with legal training represent them in court, whether it's civil, and I know that they can do certain provincial offense matters as defense.
And criminal too.
And criminal. And I will tell you, in my experience, 15 years in small claims court, the best paralegals are better than the best lawyers because they don't have the ego that goes with law school sometimes. The worst paralegals, though, sometimes are worse than a self-rep, but that's true of lawyers. The worst lawyers are worse than a self-rep party. It's all a question of competence. But if you're looking at career path, law school isn't always the right choice. Becoming a paralegal is a very worthy and very noble profession as well. And you help a lot of people in a very real way. And you're still immersed in the law, no less than a lawyer. So that's been my experience. And paralegals fill that gap sometimes for people who can't afford a lawyer at, $300, $400, $500 an hour or whatever they're charging. It's something to consider.
Yeah, and I can tell you all about that.
Very brief point, which is that the other key thing that I notice is sometimes paralegals who can't represent people on certain criminal files will still just assist them with finding things. And it is insane in law how difficult it is to find things. Like half of my job is answering emails from defense counsel, especially during COVID. Like here are the links to come into the courtroom, and here is the form you need to fill out to set a trial, and people just don't have them, and I just have them all there, right? So just having that, we call it access to justice, right? You can't access the system if you don't know where the system is.
Yeah, and certainly there are some legal clinics and things like that that are there to provide some of that legal assistance and coaching and things of that nature. All right, so thank you everyone for all your questions there and for joining us. As I was saying before, in high school we didn't have maybe Isolt and David, but in terms of these competitions, so take advantage and have fun. And I do see a last question here, so maybe just a couple of words from everyone to wrap up. Any final words of wisdom there to give anyone entering this competition, and anything to share? And thanks again for all of the panelists for joining us, and thanks for all the questions. I think there was someone else that might have had a question. I don't know if you can pop it in the chat there as well, but thanks again for everyone for joining.
I think Joanna had a question, but I'll just give my quick advice, which is to read everything twice and to really think about it before jumping to any conclusions. And the number one mistake that I see is that people are not responsive to the situation. So typically the research is impeccable, the questions are excellent, and it's all beautiful, and then something happens and no one responds to the thing that happened. So I would practice in an organic way, ask your questions to the person you're rehearsing with in an organic way, try to use different words each time, and come up with ways to address things that could go wrong, because that could really make a huge difference. And Joanna says she wants to ask about cross-examination, but I'll turn it over to Dave.
Oh, I was going to have a very simple answer to that question about trying a case in a competition for the first time, is have fun. Have fun. It's very easy to, there's no end of preparation that you can do, and this is true in any trial. You can prepare and prepare and prepare forever, but make sure you get your sleep, make sure you eat well, make sure you're alert for the trial, and have fun. Trials are a lot of fun. It's a lot of fun to be able to examine or cross-examine a witness and then present the arguments. That's a lot of fun. And so have fun doing it, and don't worry too much about making mistakes or how things may come across. You have the advantage of not having someone's life on the line in a mock trial. So enjoy it.
And Robert, also, maybe from your perspective of being a judge at some of these competitions, what can you add?
Just two quick things. Number one, don't be afraid to be yourself, because if you try to be like someone else, you're going to fail. If you do it and be yourself, you're going to succeed because you know yourself better than anyone. And number two, when you look at the judge, when you look at the opposing counsel, never put anyone on a higher level than yourself. Everyone is equal in the system. The judge is your equal. You have to show them respect because of their position, but in terms of as an individual, they are your equal. Doesn't matter if they've got 40 years experience and you're doing your first trial. Don't ever think of yourself as lesser. And that should give you the confidence. Judges are human. Judges make as many mistakes as lawyers and witnesses. The only advantage as a judge is no one's going to sue you if you make a mistake. But beyond that, don't be afraid to challenge things, and just don't be afraid. The worst that happens is someone will say no to you. But if you don't try, you're never going to get to that point. So.
No, I don't know if anyone has to drop off there, so maybe we can, David, Isolt, or Robert there, I think, because to question here from Joanna about cross-examination. Just want to make sure you're all okay for that question, or?
Yeah, I'm okay.
Yep.
Okay, so Joanna, just unmute and ask, please.
Yes, sorry, I'll make it brief. So in cross-examination, you want to be able to control the witness, but at the same time, there's like a ton of witnesses who are just uncooperative. And so do you have any tips or advice or just a general rule of how you can go about controlling these sort of witness without getting to the point where it's badgering the witness?
So I'll go first. because I also have to go. But I think briefly, the key thing is to get a sense of the person you're asking questions to, and that's true at any point in the trial. So once you have a feel for them, you can kind of feel like what they're going to respond to. And then you structure your questions and approach them in a way that works. So sometimes, you know, you can like something I do, which people often don't do, is there are certain witnesses who I know are difficult, and I will actually kind of trick them a little by asking them sort of open-ended questions to start, and then they start talking, and then they talk themselves into a corner. But that only really works when you're trying to get something out. Like I had a woman who had been having her husband, she was testifying in his defense, and he was telling her everything that was happening in the courtroom, which is a breach of the order of excluding witnesses. And I had realized this because of some comment she made when she walked in about how I knew another language. She couldn't have known that if he wasn't talking to her. So I asked her about that, and I got her talking. Another thing you can do is you can change your approach, and you can also be like very genial, like Dave was saying, be the nice guy. Defense lawyers are the ultimate cross-examiners, right? And that's how they approach the witness. They're like, I just want to be fair to you. I just want to get your evidence. So can we go through what it is that you had to say? And then they start by confirming what this person said on the key points that they need. And that line, which I've seen many people use, is very effective. So that approach where I'm just trying to be fair to you, and then you attack them with the things that don't make sense or the stuff that contradicts them after. Go ahead, Dave.
Yeah, I've definitely used that line on a number of occasions. I just want to be fair to you. But yeah, I think your question when you asked about badgering a witness, I think you know, you can't be. I was going to say you can't be discourteous to them, but I guess you can be discourteous to them. You can't be, I guess, aggressively discourteous or hyper aggressive with them. But your job is the advocate, right? And so sometimes you're going to have to ask questions of a witness that are not nice, and you're going to have to challenge a witness in ways that are not nice, and that's your job as an advocate. So that's okay. And you'll have to come back to some things over and over again with a witness, and you may have to ask things in various ways. So, you know, if somebody's telling you, for example, that they kept a receipt from a bottle of wine that they had purchased 10 years ago, you might ask them about other receipts that they've kept and why they would have kept that receipt. And you may go on for a very long time about that to show how absurd it is that somebody kept a receipt for a $10 bottle of wine, if that's what they're suggesting. So I think it's okay to continue on in cross-examination, and you know, like Robert said, the worst that can happen to you is someone's going to tell you no. Like a judge may just stop you, right, and say you can't do it. But in the absence of that, if you need to get something out of a witness, you just keep going, and at some point maybe a judge will stop you, but nevertheless, you can still make an argument of why you should be allowed to continue. So if you know you can get something out of a witness, and you have to think about that a little bit, because you don't want to be doing something that you don't want the jury to hate you and love the witness. But you know, if the witness is looking terrible, keep going. That's great stuff.
And Robert, anything to add to that there about what you've seen, and like, what would you step in at any point there if you see that the counsel is getting too hostile there and are badgering, or do you let it just go and wait for an objection?
I wait for an objection, but I will step in if they're going nowhere. If they've spent an hour with a one witness trying to establish something and they're making no progress whatsoever, I'll step in and say, you know, counsel, you've asked around 320 questions on this one point. Do you have a lot more on this? Do you? And I'll encourage them to get to the point. And usually if there is a point, they'll say, well, Your Honor, I'm trying to establish A, B, C, and D, and you let it go. But other times, and this is, again, you see it with rookie mistake, it's the shotgun approach. You're going to try to spray the whole area and cover everything instead of being focused. And if I see that, sometimes I'm doing the lawyer a favor by stopping it, because you just know if they keep doing it, they're going to dig a hole for themselves. but sometimes your role as a judge is to let someone dig a hole for themselves, because it's up to the lawyers how they want to conduct the case. So it's from the judge's perspective, you don't want to wade into the dispute too much and become the other lawyer objecting to things, but you also have to maintain control of the trial. Because if I, as a judge, let everyone do what they want, trials won't last for 6 hours, they'll last for 6 weeks. And at a certain point, your job as the judge is to maintain control. And sometimes it sounds mean, and sometimes it is mean. And the reality is there's some lousy lawyers out there asking lousy questions, and you just have to jump in and stop it from becoming this, endless train. But sometimes it's also entertaining as a judge. You're almost seeing how much of a hole can they dig for themselves? Do they really not realize that they're going down exactly the opposite road they should be going? So that's when lawyers and judges are the sadistic creatures that the public thinks we are.
And note to self, there may be on point ever appearing before Robert there ever in the small claims court. So thanks everyone. Thanks to all the panelists again. Thanks John as well. And again, for all of the students here, we're going to hope to put on a few more of these leading up to the competition and even at the competition itself. Again, I'm a firm believer of great legal education. They're free resources. And I think learning from the people, there's going to be the best way you're going to do on the competition. And again, enjoy the experience. As David said, have fun because these are great opportunities, and you're learning from them, and you take some of those skills, and maybe one day, you're going to be appearing before Robert for real, and he'll remember that you appeared in a mock trial many years ago, just like he remembers his high school notes. So he has a really good memory there. So all the best. Thanks again for everyone, and take care.
Thank you.
Good night, everybody.
Good luck with the competitions.
Good luck, everyone.
Thank you.